Hey everyone, Harry here to talk about AG Letitia James proposed findings of fact and conclusions of law in the fraud case in New York, which is now resuming, and which, if the judge, Justice Arthur Engoron, adopts anything like James has asked for, will be totally a shellacking for Trump, including going forward. Okay, so recall, right? This is the big fraud case. It went on in the fall. Trump was completely contemptuous all the way through it. He showed up, however, and it seemed to be that this is something he cared about because it really is his brand on the line. Nevertheless, he acted in an obstreperous way, perfectly designed to make the judge turn against him, which the judge pretty much already had. And now it is time to face the music, and it is very, very rough music indeed. So they go through all the evidence, Trump's different kind of hijinks, and took off a month, and now it's time. This is a standard thing in a civil trial. Each side, please give me, says the judge, proposed findings of fact and conclusions of law, and the judge will issue the judge's own findings of fact, conclusions of law. Might do it totally new, might take largely one parties and just sort of scratch out and put in a few differences there. That's the way the process often works. Might do an amalgam, but here I think really that what Letitia James has submitted is likely to be the basis for the review. Okay, for the actual findings of fact, conclusion of law. Remember that the fraud claim Engoron already found had been substantiated by a preponderance of evidence standard, which is what applies here. And so that wasn't part of the proceedings. Rather, it was mainly a few other counts involving similar sort of insurance fraud, where the question of Trump's intent came to the fore, along with the intents, by the way, of Weisselberg and McConney, the number 1 and 2 people in the finance chain there, the CFO and his assistant, and the 2 Trump boys, Eric and Don Jr. Okay, so that hadn't been decided. That will now go on appeal. So part of the appeal will be everything that happens now and combined with things that Engoron already ruled. And so we're off the table at the trial stage, but will come up on appeal. Those are namely the finding that fraud had been established. And second, remember the very rough taking away of the corporate documents that permit Trump Organization and many sort of subsidiaries to operate in the first place. So that is what people have been referring to as a corporate death penalty. But we've got now something pretty close to it that James is asking for and may well get. First, let's just talk about the money. The money here is the theory is disgorgement. Remember, Trump often said during the trial, the banks got paid. What's the big deal? But Trump got much better, and these are really big loans, got much better terms than he should have had they told the truth, and that would have permitted the banks to charge higher rates. It really was riskier loans. When they came into the trial, James was saying it looks to us he's about $250 million that he should disgorge. When all was said and done and the evidence was there, the first big part of the brief goes through all the valuations of the different properties, the Wall Street property, the apartment, remember that, which was 10,000 feet, not 30,000 feet, etc. So it's all itemized, and it comes to a final price tag of $370 million, a fair bit more than the $250 she'd been asking for. Trump and his counsel say this is exorbitant, no evidence, and the like. But they actually marched through and give some evidentiary basis. Remember, they gave the defense had not much to say, a few experts, etc. So we'll see what they interpose instead for why the number should be lower. But so we're looking for starters at a much higher judgment amount. And just remember here, in terms of what Engoron says and how the appellate division in New York decides, this is about disgorgement of ill-gotten gains, not about money that they defrauded the banks out of. Okay, and that's an important distinction in measuring. Now, though, we come to the sort of belt and suspenders, if you can use that for like a corporate death penalty, because in addition, in the findings of fact and conclusions of law, James asks first that everybody, that includes Trump kids, and McConney and Weisselberg and Trump, be barred from any role in the real estate industry that, ostensibly would include showing a property or the lowest level to the highest level, and that they not be permitted to be a director or an officer, have any sort of serious operational role in any other New York corporation. That is tantamount to a death penalty, it seems to me, at least for Trump, because, what other role is he going to play? Now, importantly, that's the recommendation is that the Trump boys have that prohibition on them for 5 years, but that Weisselberg, McConney, and Trump have it for life. And here is where Trump's antics at trial and his general kind of nose thumbing at the system and the judge's law clerk really is going to hurt him, I think, because the linchpin for determining whether or not you can give permanent relief is the likelihood that in the absence of some court injunction, court requirement, they would go back to doing their bad deeds, inflating and the like. And here, James has a pretty persuasive section where she's able to say, first, they did it for 10 years. It was definitely a way of doing business. Second, when Weisselberg pleaded guilty and went to jail, instead of, for doing stuff like this, instead of purging him from the company, they gave him a $2 million sweetheart deal. And then third, and I think it's going to really be influential to the appellate division. Trump is maybe thinking, once I'm out of Engoron's clutches, it'll be different. But third is his whole behavior during the trial and his continued insistence that all the charges are baseless. And his essential high-handed insults to the whole proceeding. You get a guy like that, and if that's what they believe, then in the absence of judicial compulsion, sure seems like they'll go back to doing what they think is blameless in the first place. So his total jerk-off behavior, I think, will really serve as a basis for Engoron's being able to justify legally a permanent prohibition on Trump's and what James has asked for on Trump's having any role in the real estate industry, and that's of course the Trump brand, and being a director or officer at any other New York corporation. So that itself, if that goes through or is upheld, if Engoron adopts it, and if it's upheld on appeal, it seems to me is pretty close to what the action that people have been referring to as corporate death penalty would amount to, because he at least would be totally out of business, and his trademark brand, he's fired, as it were. I'm sure there are still things he could figure out to do. It's not quite as draconian as what Engoron has ordered with the actual companies and basically putting them into receivership, but it's a pretty rough penalty. Okay, as I said, the $370 million is for the organization and Trump and McConney and Weisselberg as a whole. And then he also imposed, based on their lesser conduct, penalties of a little over $4 million tied to precisely the conduct for Donald Trump Jr. and Eric Trump. So fines there's less, but still that's a decent price tag. They are going to be saying, they've said publicly now that they had basically no participation at all. Their role was, I think, negligible, is how their lawyers have put it, and they're going to push for no penalties against them, I think. Okay, so what happens next? The various defendants, and they are various, and they don't all have the same interest, so they will put in proposed findings of fact and conclusions of law. And I think it's later this week on the 11th that we're going to have a hearing where they're going to be, arguing over them, and then Engeron's going to go behind the curtain and maybe just put his sign off on Letitia James's findings, or vary them to some degree. But you can be damn sure that at a minimum, a very large percentage of what she's calling for, which is very harsh medicine toward Donald Trump, the judge will adopt. And that it will now go up on appeal. That'll be a long process, so things will sort of go behind the appellate curtain, as it were. But you can also be sure that one of the things that James will be saying to defend the ruling and to try to affirm it, and one of the things I think that will be impressive in a bad way to the court, to the appellate court, called the Appellate Division in New York, is the way Trump has acted with respect to all the charges, and his, brazenness and contempt, which does, in legal terms, kind of set him up for permanently being enjoined from doing business in New York, lest he repeat the misconduct that is resulting now in the very big price tag, whatever Engeron's going to cite, but something in the neighborhood of $370 million. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.